recognize all that aggression too. It's a lot of aggression going on.
I have been
with
through
Mr.
so
Davis.
much. I'm from the east side of 6
Sir,
Mile Grass here.
sir, can you hear me? Am I muted? Am I muted? Every time I say something he don't like, he roll his eyes. He grunts his nose out, his mouth. Thank you. Today is the date set for sentencing. I've had an opportunity to review the pre-sentence report, but I think this was a case. Remind me, is this the case that Mr. Smith was handling at first?
Yes, Your Honor. If the court recalls, my client took a plea in front of Judge King. I forgot. It's in front of. I have the transcript here. But he took a plea in front of another 36th District Court judge. At that plea hearing, Your Honor, my client had met with Mr. Marvin Smith, who was attorney at the time, and the assistant prosecutor at the time. And my client believes that they made an agreement that my client would plead guilty to the charge, immediately pay the restitution for the items that were allegedly damaged, and then probation would be immediately canceled, I guess, if that's the right word. Yeah. The matter transferred to you, and then at a hearing.
Okay, go ahead, counsel. I'm sorry.
At a hearing a couple of months later, my client, you had indicated that you thought that you might not give that type of sentence because you had not taken the plea and you were not part of that agreement. I had indicated that my client had indicated to me that agreement had been placed on the record in front of the other judge. I did purchase a transcript, Judge. I do have the transcript, and that was not it was not really placed on the record.
No, it wasn't. I knew it wasn't. When he said that, I knew it wasn't, but go ahead.
I mean, basically, I can read to the court. It says here, when Mr. Davis said, I thought that this was, that was going to be the deal. The court said, all right, if I can't tell you what Judge Bryant is going to do, I can tell you what I would do in a case like this. If everything was paid off and you came for sentencing, I'd probably just close it out right then and wouldn't worry about it. So long as you can show it's paid off, your attorney can motion to have it closed out and probably will. But I can't speak for Judge Bryant, and that's where we're at. So yeah. You had indicated to my client that in theory you might, I repeat, you might allow him to withdraw his plea, but you wouldn't really make that decision until the transcript was secured and the language in that portion of the transcript provided to you. And so that's kind of where we're at, Your Honor.
Yeah. I knew that didn't happen when your client said it. Why? Because I know that my colleague who came on the bench the year before I did knows exactly how it works. So when a plea is taken in the felony courtroom, it is automatically sent to the misdemeanor court. If they plead to a misdemeanor, the felony judge can only accept the plea and can never speak for the misdemeanor judge who's going to actually do the sentencing. So I knew that my colleague would not have told Mr. Davis what his sentence was going to be, because there would only be one person that knows exactly what the sentence would be, and that would be me. And then Mr. Davis's attitude was so horrible that day. I mean, it was so horrible that day. I remember it like it just happened yesterday. It was so horrible. In fact, when his lawyer came out of the breakout room, I knew that they had some strong words inside of that breakout room. And then his lawyer asked to be removed. And then Mr. Davis, he left. I think he came back, or he tried to come back or something. And his attitude was so horrible. And then I said, well, I would consider allowing him to withdraw his plea. And then I too read the transcript. And I knew that my colleagues said what he said. And Mr. Davis heard what he heard. And that's why it's a good idea to pay attention and to be cordial in court. Because then the judge comes back and remembers the attitude and behavior of the person who's asking the court to do something. And then the court is not inclined to do what the person is asking them to do, because the court remembers how horrible their attitude was the first time that they came. And I don't even think that we got to even what the terms and conditions of the probation would be, outside of the fact of me letting Mr. Smith know that this isn't some just pay and go. If a person maliciously destroys property, they got an anger problem. It's something else that needs to be addressed. This is a misdemeanor, and it is punishable at least by 90 days in the Wayne County Jail, and up to 2 years probation, up to $500 in fines plus costs. So, Mr. Applebaum, how did you want to proceed?
I'd like to ask Mr. Davis if he still wants to have the opportunity to withdraw his plea. I spoke to him this morning. I didn't. We wanted to see. We wanted to go to court this morning, and he's got. And I don't need, because you had indicated the last time you were not quite sure if you'd even allow him to withdraw his plea, but you didn't make a decision whether he could or couldn't at that time. I wasn't there when Mr. Smith obviously was there, and maybe Mr. Davis was, I'm not trying to make excuses, or maybe a little bit, but I think he was frustrated the last time because, right or wrong, good or bad, he was under the impression that he thought that was the deal. That doesn't make it right. That just means what was in his mind. So I think he was a little bit frustrated with Mr. Smith and or whoever, or maybe he should be frustrated at himself. That I understand.
For not listening when Judge King clearly said, I can't tell you what Judge Bryant is going to do. I could tell you what I would do. And then that's why when he was on this docket, he was doing what he was doing. And then he wanted to be on felonies and I wanted to be on here, and we switched places. And now he can't tell me what to do and I can't tell him what to do. And that's why we're right here, right there.
But I wanted to get that transcript to show him, and he's absolutely read that transcript. So he knows. Okay. He understands.
All right.
So the question, Mr. Davis, is, and I've not seen the pre-sentence report, Your Honor, but Mr. Davis, do you want to go ahead with sentencing with Judge Bryant? Do you want to respectfully ask to withdraw your plea, have the felony charge reinstated, then back to the drawing board? That's, we've talked about it. So you got to make a big decision.
Okay. Miss Bryant,
Judge.
Miss Judge Bryant. With all due respect, I apologize for being rude. I just felt like I was getting shambled by my former attorney, because what he took me out in the hallway and talked to the prosecutor about, yes, you're right, it wasn't put on record. But they clearly took me out in the hallway and say, take this plea and just pay this money, and I'm not going to look forward to moving forward and pressing any charges. And then go downstairs, pay the $1,200, and then everything will go away. And then so when the judge got to talking and then it got shifted, that's when I got upset. I wouldn't get upset about nothing else. I mean, I was mad.
Seemed to me like that would have been the appropriate time to ask Judge King to withdraw the plea. Seemed to me like that's why you say, has anyone promised you anything that was not placed on the record in order to get you to make the plea? But your anger was misplaced, and it was misdirected, and it was rude, and it was disrespectful.
Okay.
And having read the transcript, I don't believe that the option of withdrawing the plea is an option. Judge King was clear. Judge King was clear, unequivocally. He said, I can only tell you what I would do.
Okay, and then also, Judge, I want like they sent the papers in the transcript, and they sent the papers downstairs for me to go pay. And also, Mrs. Smith filed a motion like a week later.
Couldn't have sent no papers downstairs for you to pay because Judge King cannot impose any sentence. So there was no sentencing. There was no sentencing. Let's be clear. There was no sentencing.
I understand that, but it's in the transcript saying that we are sending the papers downstairs for me to go pay. I stayed downstairs for an hour and the papers never came. I was at the window.
Well, there is some language, Your Honor, in the transcript regarding some paperwork going down to the probation department. But
probation, a referral to probation for a pre-sentence investigation.
I agree with that. That's what I believe.
Okay.
So I
Judge,
don't,
I
I
have a
don't
reason.
think there's any language in the transcript that talks about the agreement. I'm just trying to see here. Whether, there's standard statements that are made before a plea is taken regarding promises and things like that. And it says, do you understand the rights? And you had an opportunity to talk to your attorney, and then you're waiving your rights. That was the standard thing. Anything regarding a promise of the sentencing, but let's see here. You're giving up your rights. You have a right to be presumed innocent. He goes through the standard subpoena powers. So I don't think there's any language in that transcript regarding whether any promises were made, though when they got to the last paragraph on the last page of the transcript, Judge King specifically says, this is what I would do, but I'm not Judge Bryant, and she's got to make her own decision. And never was given an opportunity after that statement. It just went right to, okay, you're sentenced, you'll get your sentencing date and be on your way. So there's some frustration on his part, justified or unjustified, as to the procedure of what happened. But that's kind of where we're at, Your Honor.
Well, it's my decision is that I'm not going to allow the withdrawing of the plea.
Then, Your Honor, I haven't had a chance to see the probation report, but so I don't know what the recommendation is. I don't know if you want to give the people a chance to send that to me, whether you can give me the highlights over the phone so I can elocute on his behalf. But I did not get an email or anything in the mail regarding a proposed pre-sentence for it. Now, maybe it was given to Mr. Smith, but I have filed an appearance in this case.
It probably was. The pre-sentence investigation is dated April the 12th, 2023. So it is the original pre-sentence report. We can send it to you and I can adjourn the sentencing, give you opportunity to go over it with your client. It's a standard recommendation. In fact, it's a little surprising to me of the recommendation for 12 months probation, since Mr. Davis has a previous conviction for aggravated assault. But nonetheless, well, I guess that's not a conviction. It's not.
Yes, Judge, is that probation reporting or non-reporting?
Oh, all of my probations are usually reporting, depending on what I order. There is a recommendation for anger management. And because of the way that Mr. Davis always acts when he comes to my courtroom, he definitely needs anger management. So there is a recommendation for anger management.
I hope he's presenting himself professionally this morning, Your Honor. He hasn't raised his voice. He hasn't seemed too frustrated. I think I
fashion myself a body language expert. That's a part of what I'm gonna do when I leave the bench. And every time I say something that he don't like, I'm from the east side too, 6115 Seneca. Every time I say something he don't like, he rolls his eyes, he grunts, his nose inflects out, his mouth. I'm gonna make money helping people pick juries because I'm gonna watch the body language of the jurors. I fashion myself to be very insightful in that area. So no, he has not yelled and raised his voice today. No, he has not exhibited the behavior that he exhibited before. But it is clear to me that for whatever reason and whatever occurred between Mr. Davis and Mr. Smith, number one, he's not over it. But had he gone into the courtroom with Judge King and actually paid attention to what the judge was saying, we probably wouldn't have all this anger and stuff right now. But there is a recommendation for anger management. Now, there was a recommendation in my previous case for anger management. And then I said, well, I'm going to focus more on this area. So, Madam Prosecutor, is there any objection to me reducing that anger management? And then she said, no objection. Because that's the kind of judge I am. I'm a judge who believes in an individualized sentencing, right? I'm a judge that believes in looking at the circumstances and deciding the sentencing. But from what I see from your client, that recommendation for 12 weeks of anger management, it almost should be 24 weeks. That's what I see. But I probably wouldn't do that. But That's what I see.
So, Mr. Davis, you've kind of got an idea of what there's obviously there appears to be no recommendation of incarceration. Looks like 12 months reporting probation. There's going to be some weeks of possibly of anger management. Do you want to go into a breakout room? Or are you ready to proceed to sentencing? Because you're going to the recommendation is not going to change, whether we delay it or not. And I think
it don't matter. I mean, Judge, listen, I didn't want you to take nothing the wrong way, this, that, and the other, but
No, these comments are not, these
I
comments.
have been through so much. I'm from the east side of 6 Mile Grass here.
Sir, can you hear me? Am I muted? Am I muted?
Oh, let me see.
No, I'm not muted. So at this point, I only want to know, are we proceeding with the sentencing today? And if we are, then Mr. Davis will get an opportunity to speak. But right now,
I didn't know that.
No, is, are we proceeding today? Because I've been through a lot too. Yesterday was the anniversary of my sister's death, who died young after she suffered a stroke. I've been through a lot too.
Yeah.
They thought I had breast cancer. I've been through a lot too.
Right.
I was homeless. I've been through a lot too. We all been through a lot.
Yeah.
We don't come in here and take out our frustrations on the people who've done nothing to you. No, that's not how it works. Now, I've been real patient. So counsel, I'm gonna send you and your client to a breakout room. Then he could tell you if he wants you to go over the report in detail. I will give you an adjournment if you request it, because we did send it to Mr. Smith. And I'm sure Mr. Smith, perhaps he didn't forward it to you. So let's send you both to breakout room number 3.
I think Mr. Davis can answer that question.
Oh, okay. Well, because let me tell you another observation. Remember you said, I was observing, and this what and so there's a judge sitting in my office because she's going to help with my docket next week. So she had come in to just, kind of watch and then so I go over the docket with her. She just came in after we started, and she got the same feeling about Mr. Davis that I have. She said she's from the east side too. She recognized all that aggression too. It's a lot of aggression going on with Mr. Davis. And so maybe he might want to wait, but I mean, I know how to separate. So are we going to sentencing today, or am I giving an adjournment?
Mike, you want to go ahead right now, or you want to get an adjournment?
No, please, let's adjourn it.
Okay.
No, so yeah. Yeah. Can we adjourn it, please?
We're going to adjourn to the 25th of August.
What time, Your Honor?
9 o'clock.